Okay, let's unpack this. Imagine someone leans across a table, voice low, and confesses to something truly shocking.
Right.
Now, hold that thought, because this deep dive isn't about that kind of confession. It's a different kind of revealing moment altogether, a legal ruling in Hong Kong.
Ah, okay.
And it pulls back the curtain on some really naughty aspects of financial crime and how the law, well, how it tries to deal with it.
It's fascinating how these rulings can sometimes, test the limits of the laws we have.
Exactly. We're talking serious money here, millions of dollars.
Yeah.
Complex legal arguments, too.
And some really fundamental questions, I bet. Like, what does it actually mean to handle money that might be, well, dirty?
Precisely. So for this deep dive, we're looking into a significant Hong Kong legal case. The core issue is the offense of handling property known or believed to be the proceeds of what's called an indictable offense.
An indictable offense being basically a serious crime, right? Tried in a higher court.
That's it. And specifically, we're looking at the Supreme Court's decisions in FACC 5 and 6 of 2015.
Right, FACC 5 and 6. And weren't they heard with another one, FACC 1?
They were, yeah, all heard together. Our main source here is the judgment itself from these final appeal court cases.
Which can be dense, but usually packed with the details we need.
Definitely. And for you, the learner, our mission today is simple. Extract the key insights, the legal principles from this complex ruling.
Sort of boil it down.
Exactly. Give you a clear understanding of the key issues around Hong Kong's money laundering laws, especially how the law itself is interpreted, and this concept called the no duplicity of charges rule.
Which sounds technical, but it's actually quite important for fair trials.
It is. Think of this as your shortcut to understanding a really nuanced bit of law, but one with serious real-world consequences.
And understanding these precedents is crucial if you're involved in Hong Kong's financial system in any way. It shows you the lines, the risks.
Okay, so we're actually looking at two main cases within this ruling. First up, Mr. Zhang, or as the judgment calls him, FACC 5 of 2015.
Right, Mr. Zhang, what was his situation?
His case involved charges under OSCO, that's the Organized and Serious Crimes Ordinance, for handling proceeds of an indictable offense.
Okay.
And his appeal brought up two really interesting questions. First, did the prosecution actually have to prove the money he handled was definitively from a serious crime?
That's a huge question. What do they really need to prove about the money's origin?
And second, how much detail did the trial judge need to go into about Mr. Zhang's own, beliefs, thoughts, intentions at the time?
Ah, the mental element. Always tricky.
Then there's the second case, Mr. Lee C., FACC 6 of 2015.
Okay, Mr. Lee.
His case was about handling proceeds from a whole series of fraud schemes. Now, Mr. Lee was a Dutch national living in the UK.
Okay, some international elements already.
Right. He set up a company in Hong Kong, Dayleader Limited, opened bank accounts. Then he handed control, the details, the devices, over to a Pakistani man named Yasser.
Handed control over. Interesting.
Millions from these frauds then flowed into these accounts.
Huh.
And Mr. Lee himself was involved in taking some of that money out later on.
So he wasn't just setting it up and walking away. He was involved in withdrawals too.
Exactly. So as we dive deeper, we'll unpack the legal arguments, how the law evolved, and how these ideas were applied to Mr. Zhang and Mr. Lee specifically.
And that no duplicity rule you mentioned.
Definitely touching on that and why it matters. Okay, this is where it gets really interesting. Let's start with Mr. Zhang's situation.
The sheer amount of money is staggering, isn't it? Over 721 million Hong Kong dollars.
It's huge. Across 5 bank accounts and, like you said, 963 separate deposits, cash, checks, transfers.
Wow. So the charges reflected that scale, presumably.
They did. But here's the thing. The prosecution didn't actually try to pinpoint the original crimes.
They didn't trace it back.
No. And they didn't argue he knew for sure it was dirty money. Their whole case was built on him having reasonable grounds to believe it was proceeds of an indictable offense.
Ah, the reasonable grounds standard. That's key in a lot of these cases.
And they leaned heavily on a forensic accountant's testimony to try and prove those grounds existed.
Which makes sense. It's often hard to prove the original crime, so the focus shifts to what the handler should have suspected.
Exactly. Now, the trial judge didn't buy Mr. Zhang's explanations for all the cash.
What were his explanations?
Well, for cash dealings with securities firms, he said it was urgent margin calls. The judge found that unbelievable.
Okay.
Cash checks from a Macau casino. He claimed gambling winnings. Judge didn't accept that either.
Right. Common explanations, often scrutinized.
And third-party deposits. He called them investment returns. Again, the judge rejected it.
So the judge just didn't find his story credible at all? That's a
Yep.
tough starting point for the defense.
Definitely. So Mr. Zhang got leave to appeal on two main points. First, this proceeds of crime element.
The one we mentioned earlier.
Yeah. Did the prosecution actually have to prove the funds were proceeds? This revisited an older important case called Oe Hanky Wirio.
From 2007, right? A landmark case on this very point.
But the argument essentially was maybe Oe Hanky Wirio got it wrong.
Bold move, challenging established precedent like that.
Yeah. The second appeal point for Mr. Zhang was about his mental state.
What he knew or believed.
Right. How much did the trial judge need to spell out regarding Mr. Zhang's specific beliefs or thoughts at the time, especially if the judge didn't believe his testimony anyway?
That's a subtle point. Even if you reject someone's story, do you still need to address what they claim they were thinking?
Kind of. Like, what if the judge found reasonable grounds to believe the money was criminal, but didn't fully explain why he dismissed Mr. Zhang's own stated reasons for handling it?
Yeah, the reason needs to be clear. Transparency in judgment is crucial.
Now, the prosecution also had an appeal question, which adds another layer.
Okay, what did they want clarified?
They asked about the no duplicity of charges rule, specifically for money laundering under Section 25 of OSCO.
Right, because handling can cover different actions.
Exactly. Could it be seen as one continuous offense sometimes, which might affect how strictly the duplicity rule applies?
Interesting angle. A series of acts is one ongoing crime.
And how do exceptions to the rule work when you've got multiple handling acts, maybe involving money from different sources? They mentioned examples like one transaction, general deficiency, continuous course of conduct, legal concepts for exceptions.
These exceptions are vital. The rule aims for fairness, preventing confusion, but it needs to be practical for complex situations.
And there was even a fourth appeal question, stemming from another case, Peng Hongwei.
Okay, what was this one about?
This was about squaring the reasonable grounds to believe test from the Sing Yat Fong case back in '99. With the phrasing knew or ought to have known used more recently in the Peng Hongwei case in 2014.
Reconciling different ways the courts have described the mental element, trying to get consistency.
Pretty much. Like, when should trial judges use which formulation?
Shows how legal language evolves and needs clarification.
Okay, so with all that on the table, what did the Supreme Court actually say? Let's start with Mr. Zhang's first point. Did the prosecution need to prove the funds were actually proceeds of crime?
This is a really big part of the judgment. The court looked super closely at the wording of Section 25(1) of OSCO.
The actual law.
Yeah. Phrases like, any property representing proceeds of an indictable offense, and then how it refers back to that property.
Okay.
Their conclusion was that the mental state, what the defendant knows or has reasonable grounds to believe, it relates to the nature of the property being handled.
Meaning what they think the property is.
Exactly. Do they know or have reason to believe it represents proceeds of crime? That's the focus, not necessarily proving its actual criminal origin beyond doubt.
So it's more about the belief about the property, not the property's proven history.
That's the essence of it. The offense lies in handling property believed on reasonable grounds or known to be criminal proceeds. Proving the original crime isn't required for the handling offense itself.
Did the history of the law play into this? You mentioned OSCO changed in 1995.
Absolutely. The court detailed how those 1995 amendments were crucial. Before 95, the law focused more on assisting a specific criminal, the relevant person who committed the original crime.
Okay. Helping the bad guy keep the loot, sort of?
Pretty much. The new version shifted the focus squarely onto the property itself being handled. It didn't matter so much who committed the original crime or if you could even identify them.
So less about the original criminal, more about the money itself and the person dealing with it now.
Precisely. It broadened the scope. The act of handling property perceived as criminal proceeds became the core of the offense.
What about Mr. Zhang's argument about the legality principle and property rights under the Basic Law? He argued this interpretation violated his rights.
The court didn't accept that. They looked at the legislative history, the purpose behind the 1995 amendments.
What the lawmakers intended.
Right, and it was clear the lawmakers intended to broaden the offense to combat money laundering more effectively. They knew what they were doing. So the court said the legality principle wasn't breached because the legislative intent was clear.
Okay. Now, they also talked about a UK case, RV Montilla. Mr. Zhang's team said it supported their view. How did the court handle that?
Montilla was a big UK case where their top court did say the prosecution needed to prove the property was actually criminal proceeds.
So the opposite conclusion.
Yes, but the Hong Kong Supreme Court distinguished it. They said the UK law Montilla was dealing with had different wording.
How so?
The UK law specifically focused on the purpose of the handling, like assisting another person to keep the proceeds or hindering confiscation. It was about helping someone else evade justice.
And the current Hong Kong Section 25(1) doesn't have that specific purpose requirement built in.
Exactly. Our law is broader. It focuses on the act of handling property known or reasonably believed to be proceeds, without needing that specific assisting another purpose. That difference in wording was key.
Interesting distinction. Did the Vienna Convention come into play?
It was mentioned. The 1988 Vienna Convention requires signatories to criminalize laundering drug money.
Right. International obligations.
But the court noted the convention allows states flexibility in how they implement the exact form and severity of their domestic laws. So Hong Kong was free to adopt its specific approach in Section 25(1).
Okay, that makes sense. Now, what about Section 25A of OSICO? How does that fit in?
Section 25A is really important context. It provides a procedure for someone who knows or suspects property might be criminal proceeds to make a disclosure to the authorities.
Like reporting your suspicions.
Yes, to the Joint Financial Intelligence Unit, for instance. And if you make a proper disclosure before handling the property or as soon as practicable after, it can provide a defense against a charge under Section 25(1).
So it's a mechanism to protect people who might encounter suspicious funds but act responsibly.
Exactly. It addresses that concern raised in Montilla about potentially criminalizing someone who handles funds they mistakenly think are criminal. If you have suspicions, you report them. That offers protection.
Got it. Okay, that clarifies a lot about the court's reasoning on Mr. Zhang's first point. What about Mr. Lisai's case? What were the specifics there again?
Right, Mr. Lisai. He faced 4 charges, each tied to one of the 4 bank accounts of his company, Day Leader Limited.
And the charges covered the total amounts deposited during a specific period.
Yes. Between the account's opening and late February 2012, it totaled around HK $8 million across the 4 accounts.
And the prosecution's angle was that he was instrumental in setting up this channel for fraud proceeds.
Pretty much. That even though he lived abroad, he incorporated the company, opened the accounts as sole signatory, knew they'd be used for large sums, and later came back and withdrew funds himself. They argued he was assisting Yasser.
And his defense.
He admitted the withdrawals were handling, but denied handling the initial deposits because he claimed ignorance and said Yasser was in control. Crucially, he denied having reasonable grounds to believe the funds were criminal, claiming Yasser deceived him.
The trial judge didn't believe him.
No, found him dishonest, rejected his explanations, and inferred he knew the accounts were for handling large sums. Found him guilty of assisting and abetting the handling.
And his appeal against that conviction failed.
Yes, the Court of Appeal dismissed his appeal against conviction.
So the conviction stood, but the prosecution still had that appeal about the no duplicity rule in his case.
Yes, because each of the 4 charges covered the total deposited into one account over a period involving multiple deposits. The question was whether framing the charges that way was proper under the duplicity rule.
Okay, so let's dig into that rule more broadly now. The no duplicity of charges rule. What's the core principle again?
Fundamentally, it's about fairness. A single count, a single charge on the indictment should only allege one offense.
One charge, one crime.
Basically, yes. It's rooted in common law, codified in rules. It ensures the accused knows exactly what they're defending against, avoids confusing the jury, helps with sentencing, and prevents double jeopardy being tried twice for the same thing.
But you mentioned exceptions, based on cases like Merriman, Tomlin, Barton. How do those work?
They show that the rule isn't rigidly absolute. Sometimes a series of acts can be treated as part of a single transaction or criminal enterprise. Like, continuous theft from an employer over time might be one charge, or a series of related fraudulent acts as part of one scheme. If the acts are sufficiently connected, they can sometimes be rolled into one count if it's fair to the defendant.
So could money laundering under Section 25, with its various ways of handling, be seen as one continuous offense sometimes?
That was debated. It's complex because handling often involves distinct acts. But if those acts are part of a single ongoing plan involving the same funds or same criminal purpose, the argument is maybe they can be treated as continuous for charging purposes.
How did this play out for Mr. Zhang with his 963 deposits and Mr. Lai with multiple deposits in 4 accounts?
Well, initially, the Court of Appeal had found Mr. Zhang's charges duplicitous because of the sheer number of deposits and lack of specificity about which ones form the basis of the charge. But crucially, they found it caused him no unfairness.
And
For Mr. Li, since each charge related to a specific bank account, the duplicity issue seemed less problematic initially to the Court of Appeal. However, the Supreme Court ultimately disagreed with the finding of duplicity in Mr. Zhang's case.
They disagreed. So they thought Zhang's charges weren't duplicitous.
They overturned that specific finding. They felt that grouping the deposits could be permissible, especially looking at how other jurisdictions handle similar situations.
You mentioned Australian and U.S. cases.
Yeah.
Musad, Hamzy, Maloney.
Exactly. The judgment discussed those, showing that other courts often allow multiple acts within a single money laundering charge, provided they form part of a connected scheme. And again, the key is no unfairness to the accused.
So the focus shifts to fairness rather than a strict count of acts.
That seems to be the practical approach endorsed. Can the defendant understand the case against them and defend themselves properly? If yes, grouping connected acts might be okay.
Okay, let's circle back to the mental state, reasonable grounds to believe.
Mm-hmm.
How did the court finally clarify this? You mentioned Xing Xuming and Peng Hongwei.
Right. There was this evolution. Xing Xuming talked about objective grounds and the defendant subjectively knowing those grounds.
Okay.
Peng Hongwei focused more on identifying the facts known to the defendant and then objectively asking if those facts gave reasonable grounds while not totally excluding the defendant's own perspective.
A bit complex. Did the Supreme Court simplify it?
They did, essentially. They endorsed the simpler approach from the older Seng Yuet Fong case.
Which was?
Did the defendant have reasons to believe the property represented proceeds of crime? And were those reasons objectively reasonable? That's the test.
So focus on whether the grounds existed and were reasonable based on what the defendant knew.
Precisely. It's about having those reasonable grounds objectively assessed based on the known facts.
Okay, so putting it all together, what were the Supreme Court's final conclusions across these cases?
Okay, key takeaways. First, biggest one perhaps. Prosecution does not need to prove the property actually is proceeds of an indictable offense for a Section 25(1) conviction.
It's about the belief or reasonable grounds for belief.
Exactly. The offense is handling property the defendant knows or has reasonable grounds to believe represents such proceeds. And because of that, the Oe Henki Wirio precedent was confirmed. It stands.
Okay, Oe Henki Wirio upheld. What about duplicity?
The no duplicity of charges rule needs care in money laundering cases with multiple acts. But a single charge can be valid if the acts are part of the same transaction or criminal enterprise, and it causes no unfairness to the defendant. Flexibility is key there.
Got it. And the mental state.
The test for reasonable grounds to believe is look at the facts known to the defendant, then objectively assess if those facts would lead a reasonable person to that belief. The Seng Yuet Fong standard holds.
So what does all this mean for you, our listener, the learner? What are the core things to grasp from this legal deep dive?
I think the main point is that Hong Kong's approach to money laundering really hinges on the beliefs surrounding the funds, whether it's actual knowledge or just reasonable grounds to believe they're tainted. It's not solely reliant on proving the original crime.
Which can be incredibly hard to do.
Exactly. And the duplicity rule, while protecting fairness, isn't so rigid that it stops prosecutors from charging complex multi-transaction schemes effectively.
And the reasonable grounds test combines what the person knew with what a reasonable person would make of that knowledge.
Right. It's that mix of subjective knowledge and objective assessment. It shifts the burden, in a way, onto people handling large, unusual sums to be diligent. And remember, Section 25A, the disclosure mechanism provides an important safety valve.
It really paints a picture of the challenges in tackling sophisticated financial crime while upholding legal rights. Understanding these nuances seems crucial in a place like Hong Kong, a major financial hub.
Absolutely. And it highlights how the law is constantly adapting, trying to keep pace with criminal methods.
Thinking about the ethics here, it raises questions, doesn't it? Should the standard be higher? Should prosecutors have to link funds to a specific crime definitively?
Or does the current reasonable belief standard strike the right balance? It's a tough question how best to combat serious financial crime without over-criminalizing legitimate activity that just looks suspicious.
It really is. And that leads us to some questions for you to think about. Is it fair, in your view, to convict someone for handling money they reasonably believed was criminal, even if maybe it wasn't proven to be?
Yes, no, maybe it depends.
And what about charging? For multiple suspicious transactions, should each one be a separate charge? Or is it okay to group them if they seem connected? Again, yes, no, or does context matter most? We'd genuinely love to hear your perspectives on this.
Definitely. Let us know what you think. And maybe a final thought to leave you with.
Go on.
Given the sheer complexity of finance today and how clever people can be at hiding money, how do these laws need to evolve next? How do we keep them effective against criminals without making life impossible for legitimate businesses or individuals who might get caught up in something that just looks off? That's the ongoing challenge, isn't it? Balancing effectiveness with fairness in a constantly changing landscape. Something to keep watching.